Hello everyone. Let's see if the stream gets started correctly here. Hello, hello, hello. Blackleaf is very stoked. Oh, I just realized I'm running this camera on battery, so we're also going to be keeping it short for that reason. Good evening, good morning, good night, everyone. I'm Leonard French, your favorite copyright attorney. Yes, I'll be turning the music down in a moment. Does anyone even hear the music? We've gotten this complaint before.
Yes, the music is audible.
Okay. I'm just giving it a minute while we get started here. Pennsylvania was beautiful today, Dustin. Thank you very much for your comments. Yes, we did the audio sync. We're getting a checklist together now, believe it or not. We've got like a procedure for how to do this so it goes right. I even have a little light in front of me that I can adjust, you know, to make myself a little warmer. See there, isn't that a little nicer? It's a nighttime stream, so I get to turn the lights down. Honestly, I think the 14,000 lumens is a little bit harsh. So, my day's been good. I don't know if you saw, I did a bunch of Imagos stuff this morning, and then we streamed Helleborn for like 6 hours this afternoon, which is a little bit longer than I anticipated, but it was fun to take a break. Notice the nobodies, the ramblings of a nobody says. Nice. I am hatless. We're doing a thing. I go hatless when we do these live streams. I don't know if I've kept it going perfectly, but it seems like a good idea. Yeah, Mindhunter is cool. I like Mindhunter. Who's the director of that? I forget, the same guy who did Fight Club, right? Damn it, I forget his name. Anyway, Lawful Masses After Dark, thank you very much. Leonard After Dark, oh, both of you, from our Potter and from the Native Lava, thank you very much. This is going to be a short stream today. I'm basically going to let this song finish and then we'll get started with, it's a 2-page, it's 2 single-page documents, and so we're going to take some questions. Brandon is with me here, and we're going to end the song. There we go. And hello, everyone. I'm Leonard French, your favorite copyright attorney. And yes, the director of Mindhunter is David Fincher. I'm really not sure how I forgot that. But so far that series looks pretty good, and David Fincher, the director of Fight Club, is an amazing director, so I'm definitely looking forward to checking more of that out. But tonight we are here to talk about the Imagos case, Imagos versus Alex Maurer. This case is still going on. I know a lot of us, including myself, were very excited to try and put this case to bed. And, well, I may have been a little bit too eager, or at least that's kind of one of my suspicions. But not that I was too eager as in anything was done wrong, just, you'll see. Let's go over it. So, you know that about a week ago, I filed a motion to strike Alex Maurer's answer that she filed late. You would think that if the rules of civil procedure are violated, well, they're strict rules, and we don't let anybody through unless they can show good cause. Well, the judge thinks that I might have been a little bit too strict there, and he has denied our motion to strike and has set some deadlines in the case so that everything moves along a little bit faster from here. And we'll see. We'll go over that right now. If you have any questions about this case, we'll be taking those questions via link, and Brandon is going to provide that link in the description or chat or something. Probably both, I hope, Brandon. Brandon's also here. He's muted, and so when it comes time, he's going to join us, and we'll have a little radio-style question and answer session. So let's get right to what the order is in the case. The dog roll is still up. Pardon me. Let me kill the dog roll. And we'll kill the playlist, because we're not doing the music tonight. And anybody, I think everything else is good. So this is the order. And now this 17th day of October, upon consideration of plaintiff's motion to strike, the ordered motion is denied. And then the judge gives us a footnote here. And I need to adjust my screen so you can see the whole footnote. Hang on one sec. If I do this and then this, now you can see the whole footnote. Plaintiff's motion was prompted by Mauer's 1 day late filing of an answer. The court is putting Mauer on notice that it expects deadlines to be met. Litigants representing themselves are entitled to a certain degree of latitude in their pleadings, but they are not free to ignore deadlines. The court will not, however, strike a pro se litigant's answer or sanction that pro se litigant because the answer was filed 1 day late. Plaintiffs are not going to achieve victory by default here against a defendant who is clearly interested in defending herself. Moreover, the court disagrees with plaintiffs' contention that a 1 day delay has prejudiced their claims. Plaintiffs assert that they are in genuine need of prompt relief because they cannot develop their video game while this litigation is ongoing. But plaintiffs are not unique in asserting that they need quick resolution to litigation, and there is no order from this court which is keeping plaintiffs from developing their video game. Finally, if plaintiffs believe that this litigation will be sped up by having a default entered, possibly followed by a motion to set aside the default, with its attendant briefing and potential appeal, plaintiffs have miscalculated. The court also declines to hold Mauer in criminal contempt or impose Rule 11 sanctions, either of which would be a draconian sanction here. So, my major disagreement with the judge seems to have been, I felt that Mauer was 2 months and 1 day late, and he feels that she is simply 1 day late. I took the court's order more seriously than I guess the court did, and I don't mean this to be like disparaging or insulting to the judge or disrespectful in any way. I just mean that when the judge said that she had till August 21st to get an attorney, and she didn't do that, and when the judge said that she had till September 25th to file an answer, and she didn't do that, like that said to me a lot more than what he's saying here. I thought that he was being more strict with her than he was saying here. Now, one of the ways that we get that kind of relief is if we ask for it. It doesn't always happen. You can't count on it happening all by itself. And many things in court don't happen by themselves at all unless you ask for them. And the judge will actually kind of sit there tapping their finger or their foot and be like, counsel, I need you to make a motion, because they can't move on until you say something. In this case, the case would move on without me if I didn't say something, so I wanted to say something and hope that the judge would grant our request. The answer is no if you don't ask, so at least we asked. What I may have done differently in hindsight is, now knowing that Alex did respond once I notified her of the default, maybe I should have waited longer before trying to default her, but then I'm not sure if the judge would have seen our waiting as, I don't know. So even if I had filed a default later, it's still possible she might have immediately filed her response and the judge might have still considered that to be okay. Why the judge considers this to be okay for a pro se litigant who swore up and down that she wanted to get an attorney and then didn't get an attorney or tell the court or anything, I don't know why all that is allowed. Perhaps Judge Schiller is just more tolerant of these procedural things than I am. Perhaps I'm biased because I spent, 12 years going to school and, a couple $100,000, getting my degrees and everything, and kind of feel like, hey, I did my job, so why shouldn't that be rewarded with the appropriate action from the court? Either way. I also read Rule 55A, which is the motion for default, to say that the clerk must enter a default, and I'm not sure why the clerk did not enter a default. Now, the judge seems to be thinking about us too, and he says that we have miscalculated if we think that having a default entered and then having a motion to set aside the default, maybe the judge thinks we've miscalculated, or at least I'm sure the judge thinks we miscalculated, but I don't think that we miscalculated there. I'm fairly certain that a motion to set aside the default would still be difficult to open, would still be difficult. I don't think Alex would have been able to show the requisite good cause. But I'm also heard, both before this and after this, that Judge Schiller likes to have things heard on the merits. And I also knew that most federal judges like to have things heard on the merits. And I have definitely seen judges not be so strict with procedural deadlines before. So, that being what it is, the judge then scheduled us for a conference on November 8th under Federal Rule of Civil Procedure 16, which requires a pretrial conference between the pleading stage and the trial stage. Pretty much before discovery, but not like discovery can't begin. So November 8th, 10:30, courtroom 13B, 601 Market Street, Philadelphia, will be the date of that conference. I've been to these conferences before, and they are often not open to the public. The courtroom is open to the public, but the actual conference will be held in chambers. I don't know if that's Judge Schiller's policy or not, so I couldn't tell you if anyone who wants to join and is in Philadelphia on that date could join to watch what happens or not. But I'm going to be there on that date. The party shall make the required initial disclosures under FRCP 26A and shall commence discovery immediately. FRCP 26 is some required disclosures that are required to be exchanged without the request of the party, the opposing party, and then discovery would be information that needs to be exchanged at the request of the opposing party. So discovery will commence immediately. It is expected that the parties shall have conducted substantial discovery by the time of the Rule 16 conference. So I got this yesterday afternoon, and this morning I notified Alex of our intent to depose her and asked her for feedback on what dates work for her. Having not received, and if I don't receive any confirmation of dates, I will simply set a date, and that will be the date that she has to attend. So we'll see what happens there. Counsel are directed to obtain Judge Schiller's scheduling policy and conference information report from the PAED website, and review the policy before making the conference information report, and bring the completed information report to the Rule 16 conference. And counsel are expected to be registered ECF users. This is all fine. I'm counsel. This is probably a notice to anyone who's about to become counsel. It's probably the judge's boilerplate notice. It's signed by the clerk. It seems to be a kind of boilerplate kind of thing. So that's what that is. That is all that is. The judge denied our motion and set a conference date. From here, I'll be conducting aggressive discovery like the judge has requested. It's not a terribly complicated case. There's only so much I have to ask, and there's only so much I have to prove. So this should not be difficult, and it should become apparent if Alex is going to continue to, well, from my perspective, not respond or obfuscate or protract. Then we'll see. So it is what it is. You can't win them all. I thought I did a good job with the motion, but the judge disagreed. So it is what it is. What do you think of that? Do you have any questions? Do you have any thoughts? How about Brandon? Do you have a bunch of questions for me?
Many questions. Still going through them, but I do have some I can ask for you.
First answer, this is root beer. This is regular root beer. I do not drink alcohol on stream, especially not with, when I'm covering something for a client. Sorry, I just like to make that clear.
Yeesh.
Go ahead.
All right, you ready for questions?
I am ready for questions.
All right, question from Brendan. Is the judge allowed to watch your videos on the case? Could that be a source of bias against you?
The judge is technically not... I don't know off the top of my head exactly where that line is. The judge is not allowed to be biased, but what the judge can see in the news or online is... I'm unclear if the judge, if it would be some kind of conflict or some kind of ethical situation where the judge would have to recuse themselves if they saw my videos. In fact, quite the opposite. When I do these videos, I mean, even when I do the regular videos, I try to conduct myself as if a judge or my mom was going to see the video, and assume that I should conduct myself in an appropriate way. And if the judge was to see it, I would think that the judge wouldn't really find anything to be biased about. Nothing that I'm saying here is anything more than advocating for our side, and I'm just doing it in a new media kind of fashion when a lot of people are used to the lawyer standing on the courthouse steps and talking to the cameras. Here I have set up the cameras in my room, in my house here, in my studio, and I'm doing this in a new media kind of way. Yeah, Distranagant. Wow, I don't... Disastranagant. I think I got that right, finally. Judge to Leonard, settle down, Beavis. I think that's about right. I think he's saying you're a little bit excited here. Don't try to, don't get ahead of yourself. And let's go to see how this plays out at an actual trial. Also, I should defer to the judge. The judge has a hell of a lot more experience than I do at these cases. So maybe the judge knows something that I don't and really does think that defaulting Alex would result in some kind of motion to open, and that motion to open would be even worse than what we're going to go through with the next couple weeks of discovery and a Rule 16 conference. Brendan, you're welcome for the answer. Chris Oakes, Australian $5. Wasn't Alex given the time off to find counsel? Why wouldn't that be seen as unfavorable? I am not sure. Maybe the judge... I mean, in another sense, maybe I could be doing even more to make Alex look bad in front of the judge. I try to do as little of that as necessary. I'll certainly use genuine material facts to make someone look bad in the form of like witness impeachment or party impeachment, but I don't want to make our side look petty. And so, like, for instance, if I continued to badger the judge, if I like filed a motion for reconsideration or something, I tried to really badger the judge about this what I say is 2 months and 1 day late, and he says 1 day late, then, he's probably going to look disfavorably upon me and my client. So I'm not going to do that. I'm going to go with what the judge says. I'm going to go with the flow in that case. I don't have a really meritorious objection to go to some sort of appeal or anything like that, let alone that it would exhaust our resources, and we probably have enough resources to at least get through this next few weeks of discovery and conference. And then, well, I need to ask you guys about that GoFundMe at some point, because if this goes further than the next few weeks, we're definitely going to be running low on funds. And we're going to need some more help to get into like a summary judgment situation. So, Brandon, let's ask some more questions, and then if you could remember to remind me to tell people what we're going to be doing next, then, I guess.
Okie dokie.
Like how the case plays out from here now that these things have happened.
Okay. Question from Fair. I'm going to rephrase it a little bit. In your experience, are judges more tolerant or more patient towards pro se defendant?
Yes, they are. In my opinion, judges are often too tolerant of pro se litigants. I want to stop short of saying anything mean or unethical, but it has been my experience that many people who... I've seen both sides. Many people who are genuine, innocent, or somewhat innocent defendants are not able to afford a full defense. Even if I give them a discount, they really can only afford, a few dollars. And so we have to make a decision whether they put that few dollars towards settling their case or paying their fine or something, instead of putting on a full defense and then having to settle their case and pay the fine or whatever. On the other hand, I've been on the plaintiff's side of pro se litigants who have nothing better to do than waste my time and my client's money. And the judges are often so lenient to them that they can waste thousands of dollars of my client's money. And I'm happy to be paid, but do you understand, for me, I like to be fulfilled by my work. And when work is not productive, I don't feel as fulfilled. And so when you're constantly writing motions, but this person did this and this person did this and the judge is like, yeah, it's okay, they did that, we'll tell them not to do that, just go home, and you just spent $500 in court to try and get a judge to hold somebody in contempt, and the judge was like, no, I'm sorry, we're not doing that, and what they did was clearly contempt. It's frustrating. It's not the way you want to do business. So I'm hoping that, I was hoping that Alex would get an attorney, because then at least we'd have the regular fight that everybody wanted, or that the judge would hold that against Alex, or hold Alex's behavior against her or something, and he did not. So what gets to happen from here is like I said, we get to go into aggressive discovery, and in some kind of deposition or other response to my questions, Alex will have to tell her side, basically, her complete side. I'll get to ask for all the details, and her answers become part of the court record. And from there, we make a motion for summary judgment, basically. I don't think a motion for judgment on the pleadings would work, but that would be what we would do now. If we wanted to try and end the case now before discovery, we'd make a motion for judgment on the pleadings, saying that our pleadings prove our case, and Alex's response doesn't disprove anything that we proved. I will look into, exactly how much her response, what it means and everything, but the standard for federal pleadings is just notice. Her pleading just has to put us on notice of what her defense is. And I'm going to guess that the judge who would deny my motion for default, for the strike and default, would also deny a motion for judgment on the pleadings, saying that her pleading is insufficient as a defense to our claims, and that it fails to state any defense or claims itself. So instead, we'll go through discovery, I'll get some things formally on the record, and then we'll ask the judge to deal with the case on summary judgment, or I don't think we have to go to trial, but we'll see. We'll see what happens. Next question.
All right, really quick, I just want to let everybody know that I am going to be rephrasing or paraphrasing the question for time saving and just to cover Leonard and stuff like that. So might not be asked exactly the way you asked it. Next up is Caius Wickersham. What was your reaction when you saw this post on the docket and read it?
Well, to be perfectly honest, I was checking my phone way too often for the past week. I know that my phone will notify me when new emails come in, but sometimes Google Inbox classifies stuff as like an update, and so it doesn't ding my phone or whatever. So when this came through, I hadn't been dinged, and I saw it, and I was very excited, and then confused, and then I had to read carefully. And then I was a little bit disappointed, and then I was like, well, did I do something wrong? What could I have done better? How do we, I guess, what do we do from here? And then I had to tell Don, I had to tell my client, and he was also disappointed, but at least we were moving forward, and we have a date, and we're going to get to discovery. And so in one sense, yes, I didn't win the easy way, but in the other sense, at least the real story will come out more now, and we'll get to see, at least as much as I can, we'll get to see what what the story really is. I mean, from Alex's side, my client's telling you the story as it really is on our side. If I'm assuming that there's not going to be some kind of a gag order or anything, but at the same time, I couldn't put it past the judge to do something like that, to ask me to stop talking about the case or something. Assuming that doesn't happen, I will. We'll be able to get the whole story basically, and certainly even if there's some kind of protective order or gag order, the story would eventually come out. But in order to get that kind of thing, you have to be able to show a certain kind of damage, and that's not being shown here. So we'll have to see what happens. Next question.
It slides kind of well into the next question. Smiley Rat asks, what are your ethical responsibilities regarding monetizing a video on the topic of a client's case?
No ethical responsibility. My ethical responsibilities don't work like that. My ethical responsibilities are, for example, to be competent, to keep client information that is confidential, to keep it confidential, to not disparage the profession in inappropriate or illegitimate ways. So there's nothing in there that says that I can't make videos. In fact, quite the opposite. We have a lot of court cases and precedent that say that lawyers do have free speech rights, and we can exercise those rights by speaking publicly, by advertising. If you believe it or not, there was a time when lawyers weren't allowed to advertise because it was seen as unethical, and now we have lots of case law that says that advertising is part of free speech, is part of your freedom of association, and your right to pursue life, liberty, and happiness, and so can't be infringed by the court. Limits can be put so that advertising can't be inappropriate, especially not for a profession that represents. See, lawyers are seen as a wing of the court. We are literally officers of the court, and you can hear an occasional lawyer try to say that in some jackass way, like they're special because they're an officer of the court. But it is true, and I can see somebody wanting to be recognized because we do actually have heightened ethical obligations to the court because we are considered a wing of the court, an extension of the court, an officer of the court. So my ethical responsibilities are mostly to the court and the profession and my client, not in that order, mostly to my client and the court and the profession, probably closer to that order. And monetizing a video doesn't have any, there's no problem with that. The problem would be if I didn't have my client's permission to talk about what happened. And I do have my client's permission. As you may have seen, there's kind of a PR nightmare going on here, and so trying to get at least our message out has been very important to Imagos and to try and save this whole Star Mazer and Star Mazer DSP projects. Without a voice, I don't know that we would have been able to raise the funds, for example, to put on the defense. There would be we'd be having a different conversation. There might not be a lawsuit now. Maybe the game would still be back up on Steam, but the project might be completely dead instead of looking. I really don't know where that would be. But what we're really hoping for now is that by the end of this case, enough of this has been done, enough of this advocacy, both in court and out of court, has been done, that not just you, not just my audience, but also consumers who would purchase Star Mazer and DSP, investors who may be interested, developers who may be interested, will want to work with Don and Imagos again, confident that they aren't going to get dragged into the Alex Maurer situation. And I can completely understand that. That is, I can understand not wanting to get dragged into I mean, everybody has to consider what they're getting dragged into when they get dragged into things. When I get phone calls, even today, hey, can you take this copyright case? I have to think, well, wait a second, I'm in the middle of the Imagos case. If I try to take something really complicated now, I'm just going to hurt everybody. Like, nobody's going to win. Imagos is going to get hurt. The new client's going to get hurt. So there's my duty of competency, which is literally Rule 1.1. It's the first rule in the book. I have to know how competent I am and only take work that I am sure I am competent taking and can maintain competency in. And that includes not overworking myself to the point that I do a bad job. So it's a constant balancing act, but so sorry, long answer to a short question.
No worries. Next question is from Morpheus Keeb, I believe. Was there a time limit you had when you were trying to file for default? Could you have waited however long you wanted to?
I could have waited a period of time, yes. I could have waited weeks or months. I've seen some plaintiffs wait to file for default, and I've actually seen some plaintiffs wait until the judge gives them permission to file for default. It was just my interpretation of the rules in the situation was that Alex had been given 2 months, and so she was 2 months and a day late, and that was just not how the judge saw it. And it's not like you can call the judge and be like, hey, judge, if I file this motion to strike, are you going to agree that... Because judges, believe it or not, have an ethical duty not to do that, not to allow that to happen, not to give a client or not to give a party an answer without a full adjudication, not to talk to a party ex parte or without the other party's notice and opportunity to be present. So it's not like I can just call the judge and ask and find out, if it'll work. You have to do the work. You have to put it through its paces and do the work. And at first I wasn't sure if we were going to do that, and then I found what I thought was really good case law explaining exactly what we needed to prove and what Alex needed to show, and it really put the burden on Alex, except that the judge didn't agree that Alex was that late. I thought Alex had disobeyed a court order, and that the court order had given her 2 months, and that meant it was 2 months and a day late. And the judge, although probably sees her as still not obeying a court order for 2 months, doesn't see that as such an egregious infraction that it deserves what I admit is a harsh sanction of losing the whole case. Also, the judge hasn't seen what our measurement of damages is yet, and I'm not even sure that we know exactly what our measurement of damages is yet. I think we're still working on calculating that. And for all they know, for all we know, it could be some extremely high number. Maybe we're going to try and allege hundreds of thousands of dollars in damages. Then Alex is that's a lot worse than if we were just asking for a piece of paper that says we own a copyright. So. That could also be why the judge is taking it seriously, because we have asked for more than just a declaratory judgment. Stephen Wilson gives Canadian 10, here's to a short case. What kinds of things would you find in discovery? Mostly the details. So I have to prove by preponderance of the evidence, by the judge thinking about the evidence and pondering it, and deciding who's right, which side is right. So in order to prove that, I do get to ask the opposing side to admit things, to provide documents, and to provide testimony under oath before we get to trial, so that we can whittle things down. And then in all of that, we'll discover what the actual issue is, discovery, and only those issues that are ripe for trial, that are material to the case and are beyond, are genuine issues that are in controversy. Only those issues will go to trial. Everything else will get settled out before trial, either by stipulation or by judge's ruling before we get there. And then if we get to a trial or summary judgment situation, only those final facts will be disputed. In summary judgment, we kind of dispute it on the papers, and if there's If the judge agrees that there's no genuine dispute, then there's no trial. But if the judge does agree that there's something that has to be heard at trial, then we actually go before the judge and testify at a trial. And so if that happens, I'm going to hope that we can get this scheduled within 6 months so that we'd be at trial before April or March. That would be great. I'd really like that. But that's about the schedule. Judges don't usually schedule things earlier than about 5 or 6 months out. We'll see. Next question.
Next question from last name Dong, first name Hari. Did Alex get a lawyer? Is there any indication that Alex will get a lawyer? Anything like that?
Alex did not get a lawyer. She was told to get a lawyer by August 21st. It was a court order. I am confused as to what effect that court order has. Like, what if she got a lawyer on August 22nd? Like, what effect did that have? So, like, I couldn't, if I can't hold her in some kind of abeyance of this order for this, like 2 months and 1 day late or 1 day late, whatever, then I certainly can't hold her in contempt or whatever for getting a lawyer after the fact. So she can probably get a lawyer whenever, but no, she has not, to my knowledge, gotten a lawyer to this day. Excandescent gives $20. Best of luck, sir. Thank you very much. Hopefully I will not need luck, but can definitely use your $20. Thank you very much.
All right.
I don't even know what that said, Captain, but yeah.
No.
Did you put that through a translator or anything?
I didn't.
Is that even a language? What language is that? Is that even a...
I think that is...
Is that like a Unicode symbolic thing?
Very strange. I don't know.
Okay. Let's not get distracted by that.
Yeah. Dell asks, do you think that going forward the judge will be less forgiving on the defendant for missing kid deadlines?
Yes. I think that going forward the judge will be less lenient. The judge literally writes here, the court is putting malware on notice that it expects deadlines to be met, and then he cites this Westlaw case. Now, again, I'm not trying to be at all disrespectful or disparaging to the court, but let me just present something to you here. Westlaw, this WL here means Westlaw. Westlaw is a legal database cataloging service. It's one of the premier or most expensive or best legal research systems available. It's made by Thomson Reuters, I think. The other big one is LexisNexis. Somebody correct me if I've got the Thomson Reuters Westlaw thing wrong. One of them's Thomson Reuters, one of them's Westlaw, one of them's LexisNexis. Anyway, normally we have publicly available cases that are cited by by certain, the court number, basically, Supreme Court, Eastern District of Pennsylvania, 3rd District or whatever. Here the judge has cited a case from 2009 that's cataloged in Westlaw, and it's from New Jersey, I think. So what I guess I'm not understanding is the juxtaposition of we give pro se litigants all of this leniency, but then we give them Westlaw citations to go figure out how to look up. That doesn't make any sense to me. How is she going to know how to look up a Westlaw citation? Anyway.
Right, if you're going to help her,
attach it.
All the way, right?
Like, yeah, help her all the way. Like, attach the case or even provide a link or something. I guess I can try typing this into a browser and seeing if it just comes up. Maybe that's that easy. But that's some of the things that are confusing. It does come up under a sign up for free to read more. Unlike one of these case. Oh, and it's not even that case. It's this other case. Okay, but it does show you can find it if you were to... Oh, yeah, great. It's also been posted somewhere else. I can't talk about that. Anyway, so that's confused me a bit as to why he's provided a more complex citation to look up, while also telling her that he's helping, that he's giving her leniency. I don't mean like unfair leniency. I think the judge is just doing his job and being procedurally lenient with pro se defendants, as these courts traditionally are a little bit. Anyway, are there more questions?
Tons more.
Oh, great.
Another one from Morpheus Keep. Do you think that Alex Mauer will show for the conference? Do you think that Alex Mauer is going to do any discovery or deposition of her own?
I do not know. I, at this point, am pretty much as confused as I think, honestly, the behavior has tried to make us. On one hand, she behaves differently in the courtroom than she does outside of it. So perhaps we will see Alex take it seriously because she doesn't want to suffer the consequences of the court. On the other hand, Alex may at some point decide that this just isn't worth it and give up. I don't know. Let me tell you what I'm not going to be doing. I'm not going to be antagonizing. I believe in the graceful way out. I don't think it hurts. I don't think it helps my client to try and hurt Alex or anything like that. I think it helps my client is if we only do what we need to do and then move on. And whatever Alex was trying to do once we've taken our meritorious dispute away, that situation can deflate on its own. It's difficult. I have to be careful. If you're familiar with the laws of thermodynamics, you think of things as energy contained in a system, and then energy changes states chemically and such, into matter and back to energy and such, all contained within a system. I don't want to add any energy, positive or negative, to the system. I want to be doing everything I can to be taking energy out of the system and putting the fire out. And so I'm hoping that she takes the case seriously, is I guess the best that I can say. If that even answers the question.
All right. Next question comes from Cliff. What about the fact that Alex's response makes pretty much no sense? What do you want to weigh in on that?
Yes, I could try to dismiss her defenses. I could try to strike her pleading as salacious, like as under a different standard. I think the judge is going to give her some leeway, and what he wants us to basically do the deposition and not really make her case for her, but at least figure out what her case is, and then we'll go from there. So hopefully that will be all we need to do. I would like to say that I only have to do one deposition and we should be done with this, but I may end up having to subpoena some things from either Twitter or some of these other services that she's used to say things, or I may have to subpoena messages that she's written on her from her to Don, or messages that she's written about the thing. And if she doesn't provide those, we have to go to court and fight over that. It depends. No, I don't think I need 2 to 3 days of deposition. I'm entitled to 1 without any additional good cause. So 1 day of 7 hours is what I'm entitled to. And even that is an extraordinarily expensive. That is at least a $1,000 to $1,500 day and I'm not talking about my fees. I'm talking about the fees of the transcriptionist and the conference room. And, well, there's been threats in this case, so maybe I need to hire a security guard or something. And then, in addition to my fee, the transcriptionist also gets paid per page. Sometimes it's a couple dollars per page, depending on what the situation is. Here, I think it's a little. A 3-hour deposition was about a $450 fee. So we'll see. It's an expense. It's a big part of the case. It's a big step, and completing the deposition will be a big deal.
Okay, next question is from Whiskers. What will you do if malware counters the Bandcamp TPTA?
I have received notice that malware is going to counter the Bandcamp, and I'm waiting for Bandcamp to confirm what they're doing, like whether they're going to recognize the counter notice or not. Once they email me that they recognize the counter notice, then I have to decide whether I file a new case. I guess this answers our question. Normally, I would file a new case if this case was already defaulted and over, and I wouldn't want to reopen this case in order to include new claims. But since this case seems to be continuing, here I'll be able to include these new claims in this case. I don't know whether I have the right to keep her Bandcamp down during the case. So the temporary restraining order, we got that because of the threat of irreparable harm. Keeping the Bandcamp up for the duration of the case isn't really irreparable harm, although I'll be making the argument that it is because it's releasing unpublished material that's not meant to be released until it's released with the game. So we'll see if the judge agrees, but again, I have to be careful. I don't want to look petty and look like I'm trying to flatten a pro se litigant unmeritoriously. Death Envoy gives Canadian $5. Thank you. As a composer myself, I personally find what Alex has done ridiculous. Rooting for you in this case, Leonard. Thank you very much. I'm rooting for us in this case, too. I agree. I concur.
Next question from Captain Yosho. Question is, can you subpoena, say, Twitter before, like, as you get your authority from the court after filing the case, to hold anything that might be deleted? Because Twitter's policy says that anything deleted is not held.
Yeah, and I know some people have been cataloging Twitter. She's said a lot of very confusing things on Twitter. I'm not 100% convinced that I need everything that she's ever said on Twitter, or even just a few key things that she said on Twitter. It might be a bit of a red herring. I agree that in a perfect world, like, we would do a forensic examination of her Twitter account and we'd put together a timeline and it would all be perfect, but excuse me, I'm not sure if you've seen the thousands of things that she's tweeted and then immediately deleted. And I think I would have to do a lot of work with Twitter to get those things, either get them back or get them to start logging those things, and we would have to pay for that. Subpoenas are not free. The subpoena itself is easy. I get to fill that out. I have the subpoena power. I can send that as long as I feel that it's within my ethical rights and obligations. But the person receiving the subpoena, unless they're a party to the case, they don't have to respond for free. They can respond and send a bill for the reasonable costs of what we're doing, what we're asking for. So, $50 or $100 or a couple $100 is not unheard of for having a person at a company respond to a legal notice. I want to say that companies who request, like, IP records from Comcast have to pay $75 or $100 or something for each one of them. I don't know what the exact numbers are. I haven't personally had to do that one, but I have paid for witnesses before. Not the same thing as paying off a witness, but rather just paying so had a contractor one time was going to come in as an expert and testify as to why the woodworking was done wrong in somebody's house. I paid him his hourly rate to come in and do that. That's not unreasonable. You do disclose that. You get to disclose that to the court, and you can't hide that. But yeah, Prism, somebody please post the GoFundMe link, Brandon.
Yeah.
I don't know. Are we even allowed to do that on YouTube anymore? Wasn't there something about not being allowed to do that?
I think you can.
You want to search for the Imagos Star Mazer DSP legal fund, I think it is, or something like that.
You want the next question first?
Yes, go ahead.
Jessica Valentine asked, consider this development to be a setback.
I don't know if it's a setback. I did definitely have my hopes up that the judge would recognize her default. But like the judge said, it was a double-edged sword. We might have gotten a successful default, and then she may have somehow made the correct motion and showing to open the default, and then an appeal, as the judge says here. If that happened, yes, that would be worse of a setback than this is. So, I don't know. It's certainly... Is it a setback? I didn't get everything I wanted, but that's not a setback. I don't think it's a setback. I think it's just I didn't get to take the easy way out. Like I'm cruising along on the Autobahn, and I see a beautiful lake, and I see a sign that says exit beautiful lake, and I get there and the exit's closed and it says detour beautiful lake is 20 miles down the road. You gotta go 10 miles down and then 10 miles back, whatever. Is that a setback or it's just a detour? It's just a detour. I think it's just a detour. You're getting a little overwhelmed there, Brandon.
Yeah,
slow mode is on.
The slow mode up to a second.
Yes, I did.
Did you get a notification for that?
Yes, everybody did.
All right. Next question comes from Persephone. What if Alex doesn't cooperate with the discovery phase or the conference?
Then I get to make more motions telling the judge that she's not cooperating and ask the judge to compel her to respond. If she still does not respond, then that is some kind of contempt. And the sanction for that is usually an adverse inference, which would be the judge assuming that what I'm saying is right and that what she's not responding to is, whatever's adverse to her interest. So if I'm claiming that we own the copyrights and she's not responding to us saying, yes, I own the copyrights, or, no, Imagos doesn't own the copyrights, or whatever. If she's not responding in the affirmative, denying what I'm asking or saying or asking her to deny, then the judge will take that against her here in discovery. This is the time to do that. This is like her last chance to do that. She can still say something different at trial, but this will be part of the record, and if she changes her story, we would be able to use that against her later on. Next question.
Next question is from Limus. When you question her for the deposition, will public for people to read?
Sorry, I thought that was have a question. What was the first part?
When you depose her, will that deposition be made public for us to read?
I don't know. I have to look over my rules for that. I have done depositions before. And I know that I've seen depositions made public before, but I honestly don't know what the rules of privacy and all are regarding that. It's supposed to be a public court record. It doesn't go on the docket, although parts of it can when I need to cite them later. But it's not like this transcript automatically goes on the docket, and it's not like you're going to see a docket entry that says transcript of deposition of Alex Maurer. It doesn't work that way. But I don't think there's anything preventing me from publishing it. So I've got to look into that. It is a public proceeding. It's not the deposition itself is not a public proceeding, but the whole court case is a public proceeding, and this is part of that. This is not supposed to be a big secret. And if there's a need for a big secret, someone has to show good cause and irreparable injury as to why those secrets can't come out during, the middle of the case, because they would have to be able to come out later at trial. So someone has to show a really, really good reason. Usually those good reasons are related to something like they have a medical condition and they don't want people to know that they have a medical condition or something like that. There's nothing like that in this case. We're not asking questions about Alex's condition. We're not asking questions about Alex's status. We're asking questions about whether she worked for Imagos under a work-for-hire arrangement and created copyrights for Imagos as a work-for-hire or not. And if she says, that she did work, that she didn't do any of that stuff, which I don't think she can because her answer says she did do that stuff. Like, I don't see this really going any other way. I really do think that I can publish that stuff, but I'm not going to commit to it I'm not going to promise you until I'm sure. But yeah, so I'll be able to discuss it as much as I can. That was a real cop-out of a phrase there, wasn't that, Lawyer Len? I'll be able to discuss it as much as the judge will allow me, and the judge hasn't put any limits on the thing yet. Alex does say something in her answer about wanting me to stop making videos, so perhaps the judge in his leniency will ask Alex what she means by that, and will ask me to address what in the world I'm doing making videos about the case. And I'll be happy to provide the judge with a link to my channel and a link to all the videos, and provide him with I don't know if the auto-generated transcripts are available. That would help, because I think he'd prefer to read them instead of watching my hour-long videos. But I don't do anything disparaging in here. I don't do anything in here that I would not be comfortable with the judge seeing. So I'm not worried about it at all. And I would actually encourage the judge to watch my videos, because I think it would really help him understand the case. But that's not really how it works. That we get to do that through the court process.
All right.
Next question.
Next question comes from Persephone. Is it better to win a case by technicality or by the merit of...
It's always better to win by the merits, but a technicality would have been nice.
Jesse asks, can you post the GoFundMe link, please? I put it in the description of the video, so if you restart the stream by refreshing the page, you'll see it there.
Thank you, Brendan, for the $10. Yes, there is. Sid Alpha does a great Alex Maurer series as well, and he has a beautiful voice, and you should go listen to his videos as well, especially if you need to get your, saturated on this issue. I was going to say it differently, but then that part of my brain kicked in and was like, no, you don't want to say things that are vaguely euphemistic about this particular defendant, because people take that the wrong way, especially defendant.
Alrighty.
All right. Next question.
Question from Maximum Slap. What would help Imagos more, Alex pro se or Alex lawyered up?
It would help Alex more to be lawyered up, I think. I think it would cost everyone less money and time and effort. I guess it depends. If you see Alex's efforts as sabotage or protracting or some other bad faith activity, then not lawyering up is the only way that she'd be able to do that, because a lawyer representing her would not let her do that. Would be encouraging her not to do those things, and would be sort of apologetic to the court and wanting to distance themselves from that behavior, as you saw Frank Mazzio do.
Andromeda 369 asks if it's possible for you to ask the judge for clarification as to why he made the ruling he did, or the denial that he made.
No. It's certainly I can ask the judge anything. I need to have good cause to get a response. Like, I need to have a basis in law or something. So the vehicle through which I would ask the judge to rethink this response would be a motion for reconsideration, which I have filed before, and mine were successful. But it has to be something really good for a motion for reconsideration. My best example was I had settled a case, and in the settlement it said that the defendants will pay the plaintiff a calculated number times 2. So we're going to go through, we're going to calculate the damages, and then we're going to multiply the damages by 2. When the judge saw that and made his order turning our settlement into an order, he did all of that. He said, we're going to do the calculation and pay that to the plaintiff. And he forgot the times 2 part. And so that was a really obvious one. I made a motion for reconsideration. I said, I'm so sorry, Your Honor, but you forgot about the times 2 part. And sure enough, the judge came back and said, well, hey, I did. And reissued the order, now accounting for the times 2. I don't see a mistake that clear in this order. I would need to find a case where someone had been defaulted for a 1-day late filing, or find a case that says that a judge is not allowed to say that this is only 1 day late. I don't think I'm going to find that. I don't think I'm going to find either of those cases. So I don't think I have the right to challenge the judge's discretion on this issue. I also don't think it would be wise or appropriate for me to do so, or in the best interests of my client. Next questions.
Give me a few minutes to look. Maybe you can engage super chat that you might have missed, because I'm nearing the end of the list here. So.
No, that's fine. I'm fine with nearing the end of the list. We're actually going a little bit farther over where I thought we were going to go. Not that I'm upset or disappointed or anything. It's amazing that, like, I start talking and then it's suddenly an hour later.
Yeah, I mean, it's like this stuff makes itself.
It is. Well, this is kind of a dramatic case.
Yeah, we asked about 25 questions today. Thank you to everybody who submitted one. We had about 70 submissions.
Yeah, Alex and Kandar. I think that's what that is. How to pronounce that. Says we had a judge award $111,000 in attorney's fees once when it was actually $11,000. Instead of challenging by motion for reconsideration, they just paid the agreed upon figure. And that's a good idea, because in that case, filing a motion for reconsideration would have included additional attorney's fees. Like, they would have had to spend another $300 to $500 or $1,000, $300 to $500 to $1,000 to just draft a simple motion for reconsideration and file it. And then somebody has to go to court for the morning, which is even a morning for an attorney is sometimes about a half a day. So you're looking at a $1,500 minimum expense to get a correction, when really the problem is that the judge just made a mistake. And if the parties just agree, like, we're just going to overlook the judge's mistake and honor the original agreement, then there's no need to go through all of that. So I think that was a really great way to resolve that.
Also, it just seems like common courtesy, like, because I mean, at the end of the day, the person who would be paying that $1,500 for each lawyer would be the defendant, or whoever it is that was to pay the legal fees, right? So,
well, yes, there's always that. There's the blood from the stone argument, not every defendant or party who ends up having to pay something actually has the money to pay on hand. Sometimes they don't have it at all, and sometimes they might not ever be getting it. So sometimes you take what you can get and you consider how much effort you're going to have to put in to get the rest. And there's the blood from the stone. How much more blood can I get from this stone? Because I'm wringing this stone with my hands, I'm only going to be getting my own blood from this stone. So that's the analogy, and why we cut it short sometimes and take our losses and move on, even if we have to pay some money. I don't like that. I'd like it if the system was pure and every single meritorious dispute could be fully adjudicated without any consideration of resources and time. But we live in a real world with real entropy and real physical laws, and unfortunately they have limits, and we all have limits.
Before we finish up, you told me to remind you to tell everybody where we're going next with this.
I thank you. I did actually go over that a little bit.
Oh, sorry about that.
But what's going to happen next? No, it's okay. What's going to happen next is we start discovery. I will have a deposition, or at least try to hold a deposition with Alex. Assuming it's successful and everything, we'll proceed forward with the judge's conference. The judge will set some dates, and I'll be working on a motion for summary judgment. If Alex doesn't show up or doesn't cooperate with the court procedure, then we're going to have to file a bunch more things and ask the court to basically force her to, or to recognize formally that she is not responding once and for all. So it really just depends on whether she whether she responds or not, and the basics of how to get through that. So there's not. The interesting part will be the deposition, and that I get to hold privately, and I'll have to figure out how much is appropriate to say from there. But you know me, I'm not going to hold back what I don't have to, so we'll definitely reveal what we're allowed to reveal. But that's not the point. The point is to discover what the evidence is that we're going to use in the Imagos case. So that's the priority, and not to try and find anything else out. It's all about what's going on in the Imagos case. So that's yeah, I'm not sure why the name didn't get changed. Paradox. That's not my doing. That's the judge's doing.
Really quick, just want to mention, people pointed out there's a super chat from Fidos that you did.
Fidos, thank you for the $10. Thank you for making the legal system less opaque. I really appreciate your donation. That said, if anyone wants to make any donations to the Imagos cause, we're definitely going to be burning through a little bit more of the funds now that we're going to be getting into discovery and going to this other conference and all that. So if anyone feels like being generous with their wallets, the GoFundMe is up. I don't know if it's in the... I think it might be in the chat.
It's in the description.
Okay, good. Asa McQueen gives $20 and asks, does a deposition have to be in person or can it be done via teleconference? It can be done via teleconference only if necessary, like if I need to depose somebody who's across the country, whereas Alex is right here in my backyard in Philadelphia or Doylestown, somewhere in between there. And so we have actually two Veritext conference rooms. Veritext is a service that does this kind of court reporting, all full service. I just call and set it up. It's actually really nice. They even have refreshments and candies and snacks and stuff so that you can feel at home while you're doing your deposition. It's really nice, and it's not like extra expensive or anything. It's just that's their business. They do just that, and so they do it really well. So there are offices right near where Alex lives, so there should be no problem getting to a deposition. I've already sent her the addresses, already asked her for which one's closest to her, and already sent her a list of dates and asked her to respond with what dates work for her. So if she doesn't respond by about tomorrow, I'm going to be making those decisions for her, and we'll go from there. So, you heard dogs.
Doggos. Yes, that was the next thing I was going to say.
Oh, well, let me see if I can find a dog. Are there any puppies?
My dad's work used to run a place that kind of on the side, they had some set up stuff like that.
Stay up here. No, you stay up here. Stay up here. I know, you hate being up here. I know you do. I know, but everybody loves you. I know, but everybody loves you. I know. You're such a good girl. You're such a good girl. That's my good girl. Thank you for staying. You never come up here. It's always Nico. Here, I'll put some of the outro music on. What do you think? Oh, nope, we've lost the dog already.
I've noticed that Nico likes to be in your lap a lot more than Elsa does. Oh, that was the most loving lick I've ever seen.
Yeah, she's a very loving girl, despite being not the most cuddly. Nico, are you coming? It's Nico's turn. Brandon, did you miss John Wimpany's question?
Nico. Possibility. John. Let me...
Hup. Come on, Nico. Come on, hup. Come on.
Not seeing one on here.
Woof. Yes, that was awkward. That's why you do it.
Did he put a different username on the sheet? Because I'm not seeing anything.
I don't know. Rip, I think they missed my question under Vayl. V-A-Y-L?
V-A-Y... Got it. What is the fastest you've ever seen a case solved?
What was the fastest I've ever seen a case resolved?
Yeah, I'm guessing he like your case.
They aren't usually resolved that quickly. I mean, it's kind of a difficult question to answer because I do a wide spectrum of cases. Sometimes I've solved cases, somebody calls me and I've been able to solve and settle the case that very same day. No, I'm not sure that he knows that he's on camera. Thank you, though, Native Lava. Sorry, what was the question?
What's the fastest case you've ever seen?
Oh, fastest case. Yeah, so from start to finish, the fastest case was like 3 or 4 months. And most of them are 6 to 8 months. That's about the fastest, yeah.
And I'm sorry if we missed your question. I just did the math, we had 77 questions asked. We only were able to get to about 25, so...
no worries.
Could definitely not get to everybody, you know?
Yep. So thank you, everyone, for joining me. Especially thank you to Joshua Meinzinger, John Steele, John Cripps, Nate Beck, and Lydia Collinson. Oh, and Westin Lohne. You are my $50 plus supporters on Patreon for the month of October. And the rest of you are in the description below and scrolling in the LED panel behind me. That is my $5 plus supporters. And then we have a bunch of other supporters who support at the $1, $2, $3 level, who don't get recognized the same way, but everyone gets the Patreon tag on my Discord. You can join us on our Discord for live chats and things, especially with me and Brendan as we hang out and play video games. There are a bunch of people on our Discord now. It's what, like 3,200, 3,500 members or something? It's big.
Yeah, we're at 33 right now. 3,300 members on the Discord.
3,300.
We are regularly
so
housing online,
So thank you all for joining me. Have a good night. I'll let you get back to your lives, and I'll have an update for you the next time that, well, the next time there's a big update in the case. So have a good night, everybody. Love you all. I'm Leonard French, your favorite copyright attorney, and I'll see you in my next video. Say bye, Nico.
Let me know when we're out.
Yep, just one moment.